Let's go. So good afternoon to you all. I'm Marjolaine Viret, and I'm really happy to welcome you to this second edition of our Zoom-in series with Dr. Antoine Duval here virtually at the Asser Institute in The Hague. And it's a pleasure to welcome our three honorable guests today. So first, ladies first, and unfortunately today without webcam for now, it's Dr. Katarina Pietlovic. Katarina is a lecturer in sports law at the Manchester Metropolitan University, and she's authored in particular the book EU Sports Law and Breakaway Leagues in Football, drawn from her doctoral thesis work. Then Professor Stephen Weatherhill, who is professor of European law at Oxford University and is a renowned expert on European law questions, including on their interplay with sport. And last but not least, Dr. Ben van Rompuy, who is assistant professor of competition law at Leiden Law School and who incidentally represented the two athletes in the matter that we are here to discuss today in their complaint before the European Commission. And of course, not to forget my Zoom co-host, Dr. Antoine Duval, who is a senior researcher in charge of the international sports law within the Asser Institute, and who also knows a couple of things about sports and EU law, and in particular wrote his PhD on the interactions between the Lex Sportiva and EU law. So I think we can say without too much exaggeration that the topic we are here to discuss was one of the big decisions of 2020 for international sports law and for all those who are interested in the interplay between sports and EU law. It seems that speed skating has been set on giving some headache to the organized sports sector over the past years, and we all know that Claudia Pechstein provided materials for scholars to comment probably for the years to come. But today we'll be discussing the crusade of two other speed skaters who went out on a battle to have European authorities recognize that the International Skating Union rules that limit participations of skaters to events that are not authorized by the ICU were contrary to EU competition law. So in December 2020, the EU General Court issued its ruling on the application of the ISU to annul the EU Commission decision that had supported the speed skaters' complaints. And let's say essentially the General Court upheld the EU Commission's views, but our guest will explain the stakes much more proficiently than I could do. Now, to introduce the plan of the event, for a warm-up, our experts will each take a few minutes to discuss the ruling from a particular angle. So what we suggest, but obviously they are free to digress. First, we will take opportunity of Ben's insider perspective to walk us through the process from its origins to the complaint of the at the European Commission, so even before reaching the General Court. Second, Stefan will take over and situate the ruling in the broader EU law context. Then we will hear third from Katarina on the impact of the ruling on for third-party organizers and more broadly for the organization of sport. And then finally, Antoine will address the aspects of the decisions that are related to the role of the arbitration rules of the ISU before CAS. After that, we'll give them some opportunity to exchange on their respective presentations, and then we will open the floor to the audience for questions, which you can type in through the chat, and Antoine and I will then select them around common discussion teams and pick the questions and pose the question to our guests. As a reminder, the event is live streamed on YouTube and it's being recorded and will be publicly available after the event through the Asser YouTube channel. So now that's already more than enough from me. And now I'd like to give over, I think, directly the mic to Dr. Van Rompuy.
Hi, thank you very much, Marjolaine. And congratulations also to you and Antoine for launching this Zoom-in webinar series, which is a most excellent initiative. I was indeed asked to talk a little bit about the history leading up to this judgment, to take everyone behind the scenes, so to say, of the case. And I'd like to do that by highlighting that the judgment is a result truly of a series of very unlikely events going back to 2014. And to be more precise, I think there were 4 unlikely events that occurred. So let's start with event number 1. It was quite unexpected, actually, that if the complaint was filed to begin with the European Commission, the complaint that started the case and triggered the Commission investigation. Some of you may be familiar with the story, but just in a nutshell, I read in a Dutch newspaper an article discussing that the ISU had informed all of its members that an upcoming event in Dubai would be unsanctioned, organized by Ice Derby. And the ISU reminded everyone, so not only athletes, but also officials, coaches, etc., that they would become ineligible in case they would participate in that event. And pursuant to the ISU eligibility rules, this would then result in a lifelong ban for the athletes. Now, I have to say, as a competition law scholar, you see infringements everywhere. But I found that this one was particularly blatant because the alleged reason for not sanctioning this event was a link with on-site betting, but it did appear pretextual because there's no betting allowed in Dubai. And secondly, and even more so, because of the manifest disproportionality of that sanction, a lifelong ban for participating in an event outside of the calendar. So I discussed it with Antoine. We were sharing offices at that time, and he suggested that I would write a blog about it. Now, I emailed the Dutch national coach with some questions because at that point I didn't know very much about speed skating. He forwarded that email, and that's how eventually we got in touch with Mark and Niels, the complainants in this case. And they were, I was asking for information, but they were actually quite interested in this antitrust thing I was talking about. So my message to them was, well, actually, you could fight this and you will win. And their response was, tell us more. So one thing led to another, and the idea of a complaint, of going to the commission and filing that complaint came about. So it was quite random, or at least unexpected. It started off with the intention to write a blog, and it ended up with a request that Antoine and myself would write a complaint and then file it. And we said yes. So that's the first unlikely event. I think that the second unlikely event was that the commission actually opened an investigation. Digital gatekeepers, Google, Apple, are very much on the enforcement agenda of the European Commission, but gatekeepers in sports, not so much. So it became clear quite soon that there was sympathy for the case, but that this was not a priority for the Commission. And one of the issues that did not help us was that speed skating is, of course, a very small sport, a very Dutch sport. So we responded by emphasizing that this is actually a case with high precedential value. And we made a report actually of all international sports federations showing that many of them have similar eligibility rules, and many of those raised similar issues. So that this was a small case, but could have high precedential value. And then we launched a Twitter campaign together with EU athletes, and the Commissioner for Competition, Commissioner Vestager, was just in office right then, and she suddenly became flooded with tweets from speed skaters that tweeted her an open letter asking her to intervene, and she took a personal interest in the case. And then obviously also we had some help from the European Parliament, and all of these factors combined made that something which looked definitely like a non-priority case suddenly changed and became a priority case. And that was to the surprise of many, and not in the least the ISU itself. I think a third unlikely event is that we then in the end got a prohibition decision. This is the Commission's first ever antitrust decision finding a violation of the antitrust rules, at least a decision involving sporting rules. And it is public information, I guess. The ISU offered along the way a series of commitments. Changes were made, for example, to the rules in 2016 in an attempt to make the problem go away. So this case was very much supposed to be a commitment case that was supposed to be closed with making commitments legally binding. I guess the ISU miscalculation perhaps was that they held on to a lifelong ban as a potential sanction, which obviously made it very difficult for the European Commission to accept those changes as being sufficient. And then I think, fourthly, the fact that the ISU appealed was actually also a bit unexpected. It caught us by surprise. I think it caught the Commission also a bit by surprise. Why? Because as you all probably know, the decision did not impose a fine, despite finding that there was a group boycott that lasted for 19 years. And the compliance measures that the ISU had to take, and this is probably lesser known, were, in my personal view, quite mild. There's still eligibility rules there. There's still a sanction up to 2 years, which personally I still find quite disproportional. But okay, they appealed, and it was not very successful. And I think actually, in hindsight, it must maybe a mistake in the sense that on one critical issue, I actually believe that the General Court went a step further than the European Commission, but that's probably something for later for the discussion when we delve into the substance of the judgment. So I'll leave it here. A series of 4 unlikely events that brought us here.
So thanks a lot, Ben, for this very hands-on overview. Now I'll give over to Stefan for his intervention.
Thanks very much, Marjolaine. I think we have a very good team on the field this afternoon. I'm really the veteran. I've been doing this for a long time. My first sporting memory is from 1968, watching the European Cup final between Manchester United and Benfica on black and white television pictures. And I remember the 1970 World Cup in Mexico, which was wonderful for the Brazil players at the time, but also because we could watch it in color, which was very exciting. And I've been doing sports law for a long time. I was writing about sports law a long time before Mr. Bosman came along. So my comments are really about trying to put the International Skating Union case into the big picture, the long march of European sports law. And there are 2 generations of European sports law. 2 generations judged according to the structure that the court brings to its analysis of the application of EU sports law to sport. The first generation was most of all the generation of Waravin-Koch and of Bosman. Those were cases where the Court of Justice talked about purely sporting rules which would be immunized from the application of European Union law. Rules which would be an expression of the absolute autonomy of sports federations. That was the thematic discourse of the first generation of EU sports law. And it was really problematic. It was hard to identify what really are purely sporting rules. And it was intellectually unsatisfying because most sporting rules also have economic consequences. They may be sporting rules, but they're unlikely to be purely sporting rules. The reality is that sport and economic commercial effects are interconnected. And that was very clear on the facts of both Waravin-Koch and Bosman themselves. In neither case were we really dealing with purely sporting rules. It's pretty hard to imagine what might be purely sporting rules. So the second generation of EU sports law begins with Maker Medina and Maischen against the Commission, the anti-doping case. And the real significance, the generational shift which was brought about by Maker Medina, was that the Court of Justice embraced the interconnection of sporting practices and economic effects. And instead of trying to look for purely sporting rules, it accepted instead that most sporting rules are also economically significant rules, and it's therefore necessary to conduct a case-by-case inquiry as to whether the particular sporting rules are necessary for the organisation of the sport in question, even though they might fall within the scope of EU law. So Maker Medina is an expression not of absolute sporting autonomy, but of conditional sporting autonomy. Sporting bodies can maintain practices which are necessary for the organisation of the sport on condition that they can show just why they need such rules, and that the rules in question are limited to the particular objectives on which they are focused. And that then gives room for a sensitivity to sporting specificity in the understanding of whether the rules are really necessary or not, which then connects us to what we now know as Article 165 of the treaty and its expression of sporting specificity. Now, the important thing at a structural level of the International Skating Union decision of the Commission and of the General Court is that they are firmly in this second generation of EU sports law. They're entirely in line with the Maker Medina approach to understanding the crossover of EU law and sporting autonomy, and there's no attempt to try and draw out an idea of a purely sporting rule which enjoys some kind of absolute autonomy. And in that sense, the International Skating Union case fits really comfortably into the line of case law which was initiated by the Court of Justice in Maker Medina, and it very much confirms that the Maker Medina line is the way of the future. So we read the International Skating Union judgment and we see a clear acceptance that there are economic effects as a consequence of the system put in place by the skating union. The approach taken is to embark on a case-by-case examination, a detailed contextual analysis of the nature and purpose of the rules which are applied by the governing body, under an assumption that the skating union is entitled to conditional autonomy under EU law. They have the autonomy to maintain their rules, provided that, on condition that, they can show just why they need them, what the purpose is in the regulation of sport. So the judgment is quite open in permitting peculiar practices to be pursued in sport that one might not find elsewhere. So at paragraph 62 of the ruling, the General Court makes clear that it would be possible for the applicant to bring to an end the infringement found while retaining a pre-authorization system. So there is an acceptance there by the General Court that you do find things in sport that you might not find elsewhere. Gatekeeping here, pre-authorization. Similarly, in understanding the receptivity of the General Court to sporting specificity, paragraph 101, the General Court says that the protection of the integrity of the sport constitutes a legitimate objective. So the judgment is giving a green light to a gatekeeping function exercised by a sports governing body, but on condition that the gatekeeping function be exercised in a way which is based on objective criteria, transparent procedures, proportionate penalties, and reviewable actions. Just as in Maker Medina, the Court of Justice gave a green light to anti-doping procedures on condition that they be structured in a way that is objective, transparent, and subject to a system of penalties which is proportionate to the offences at stake. So the conditional autonomy model of Maker Medina is exactly the conditional autonomy model which the General Court uses in International Skating Union. And the absolute heart of the complaint is conflict of interest. The phrase conflict of interest is used by Advocate General Cocotte in the Moto case, Greek motorcycling case. The same phrase, conflict of interest, is picked up by the Commission in the decision in International Skating Union explicitly citing Advocate General Cocotte, and then the General Court in paragraph 75 refers to the core problem being a conflict of interest, although they don't specifically cite Advocate General Cocotte. And the story here, the story behind the conflict of interest, which was the core problem, is a story of the history of incremental development of the powers of governing bodies in sport. Most governing bodies started off a long time ago as regulatory bodies. They were there to ensure that the sport was run properly and in a uniform manner. And over time, sports governing bodies have tended to acquire commercially sensitive functions. And in some major sports nowadays, those commercial functions are extremely sensitive, extremely important, and extremely lucrative. And that incremental development, whereby regulatory powers of governing bodies are joined by commercially sensitive powers, gives rise to the risk that governing bodies will leverage their regulatory power in order to advance their own commercial interests. That's exactly the conflict of interest, which is the problem. And that's why the law responds and needs to respond. And I don't think sports governing bodies have any basis for objecting when the law treats regulatory and commercial activities as being interconnected, because it's sports governing bodies themselves that have brought about that interconnection by holding within one unit, the governing body, the regulatory powers and the historically more recently developed commercial powers. So the overall message of the Commission and of the General Court is that sports governing bodies need to think about restructuring their functions, unbundling their powers, achieving some degree of separation between regulatory powers and commercially sensitive powers. EU law doesn't dictate exactly how that shall be done, but the message of the judgment is that EU law does demand that conflicts of interests be eliminated insofar as they lead to anti-competitive consequences which are in violation of EU law. And I'll stop there. Thank you.
So thank you very much to our veteran for his very wise analysis. And I can see now that we can also watch Katarina. So yeah, your webcam is back. So Katarina, the mic is yours.
Oh, hello, sorry, I was on a mute. So I will talk about the effect of the ICU on third-party organizers. And as Stephen said, regulatory monopolies in sport that have such monopolies are safe. It is, in fact, the governing body's mandate to regulate their sport and even control the markets, of course, within the concept of supervised autonomy. There's also absolutely no political will or institutional capacity to re-regulate the industry by the EU or to insist on the system of competitive private regulation. So nobody has ever really seriously brought into question the regulatory monopolies and their legitimacy. So that will remain, and any third party has to accept then the regulatory authority of the governing body. And in this context, I just thought to mention before I start that I thought that the part of the Commission decision where they suggest to abolish pre-authorization system as a way to remedy the breach of Article 101 was particularly insensitive to the role of governing bodies in controlling the market, because if they don't do it, if they don't say, okay, we will license whoever organizes sporting events, who will do it? And this further then suggests that important public interest goals would be left entirely in the hands of these third-party organizers. They are private entities, basically without any mandate over the sport, and that are just there to earn profits. And that is clearly not also workable from the point of view not just of lack of protection for those public interest objectives, but also they coincide with some of the competition law objectives. So that's as much as I will mention about the regulatory autonomy, which has to be accepted by the third-party organizers. But in terms of monopolies or dominance on the organizational market, so as Stephen mentioned, that commercial function or simply the mere regulatory monopoly and control of access without even the dominance, control of access to the market. So I would like to add that there are some, and I will just a moment. So these are the legal parameters then for system of prior authorization for that gatekeeping that would have to be complied now after ISU decision. And I say would have to be or should be complied, and I'll keep that in mind. I will mention something then at the very end. So ISU paragraph 87 provides that any licensing criteria has to be exhaustive, so that the governing bodies cannot just say, okay, these are the criteria, and then anything else that we might come up with later, and then that kind of leaves the door open for arbitrary rejection of decision of authorizations. Paragraph 88 sets forth that we have to have clearly defined, transparent, non-discriminatory, reviewable requirements that are capable of ensuring the effective access to relevant market. And this is something that is not quite new. We knew this, and we knew this from the very last case mentioned there from Canal Satellite, which said, in addition to these requirements that are in paragraph 88, and the judgment didn't quote them, because Canal Satellite is also from free market, so internal market area. But I do believe that these are the same requirements because they test the proportionality of prior authorization systems. So Canal Satellite also said that in system of prior control, criteria must be known in advance. There should be no duplication of control, so that, for instance, you are required to have a authorization by the European governing body, world governing body, each and every association concerned, which would, of course, present an administrative problem then for anybody trying to access the market. And it says that it should not deter the operator on account of cost and duration. So the timelines for review of application should be clearly indicated. And this is what the third-party organizers should be expecting to find now after ISU, in particular because it also said, it also specified that motto case is applicable also in Article 101 case. That reviewable requirement really means subject to restrictions, obligations, and review. And we don't know what kind of restrictions and obligations and review that is. It's quite vague criteria. We don't know if the internal review would be sufficient or if the court access must be provided for this particular criteria to be sufficient and to amount to the reviewable criteria. So this is what every third-party organizer should be right now be able to find in every sports governing body's statutes and rule books. But what the ISU were doing, to go back to the case, is they had discriminatory deadlines where competitions staged by their members had to apply for license 3 months before the competitions, rival had to apply 6 months before the competition. And there was an obligation on third-party organizers to disclose all the information of financial nature, such as entire business plan. Now, the court said that this isn't necessarily always disproportionate, but it said that the ISU did not explain why it needs the entire business plan to achieve the objectives. And there are some other things. For instance, they did not provide for any specific time limits for dealing with requests and for authorization. So clearly, everything that they did was really going contrary to this particular criteria. The ISU amended the rules then in May 2018 for the prior authorization. And so these are now the legal parameters for sanctions on athletes after the ISU. And they're simple. the system of penalties that you impose on athletes, which are really the supply for the organizational market and should be taken as such, they must be predictable and not present a risk of arbitrary application. And the penalties should not have excessive deterrent effect, so they shouldn't also be severe. So the issue of proportionality. The question is, what are proportionate sanctions? Now we are left with, after the commission decisions and the court judgment, we are left with a basically impression that there can be sanctions, and actually that is the rule. There can be some sort of sanctions for participation in unauthorized events, but we don't know exactly what those are. One point to make is that the ultimate goal of eligibility rules was not to sanction athletes ever. Athletes were just a collateral damage, because the goal was to use sanctioning as a means to prevent entry of rivals into organizational market. And if you restrict supply, it will have a detrimental effect on the organizational market. But because rivals can simply ignore prior authorization system and stage a competition anyway, making sure they are in accordance with all the normal requirements, this is why eligibility rules are more important actually to the third party organizers than the actual prior authorization system. And there is more. These are the current reformed eligibility rules. And I have actually looked at them to just find that right now in speed skating, anybody can just, without any authorization, throw an event. That is because there are no means to going after the organizers that otherwise comply with all the requirements. And for skaters participating in those kind of events that otherwise comply with all the requirements actually just results in a warning at most. So that is the way that I'm reading part one, is that it really leaves a possibility to organize a competition without a license and still be able to secure services of the skaters time after time after time. And at the same time, of course, athletes are then given a burden of assessing whether the alternative event complies with all the standards, so as to determine what kind of sanctions should be applicable to them. As you can see right now in ISU, you can get, if you participate in a non-sanctioned event where event clearly would not have been sanctioned, so it means they're breaching one of those really important sporting objectives, such as integrity of sport, safety of events, and so on, in which case, of course, athletes should get some sort of sanction. That is kind of different, and there is up to 1 year for that. And in any case that is repeating, then it's up to 2 years. So from warning to 1 year, we really don't know. And I think that this should be clarified in order to perfectly comply with the law. There are legal options in case of infringement by the sports governing body. So if the third party organizers does not find these conditions present in a governing body's rule books, they can challenge the decision before the CAS. And in national courts, they can ask only not for annulment, but for action for damages. Complaint can be submitted to national competition authorities or to the commission. And finally, I thought to just address as a very last point, that there is a possible issues with the effect of ISU. What I have been discussing is what should be the case, what kind of conditions third party organizers should find existing now. However, and right now, actually, we should see all sports federations amending their statutes and rule books to comply with these requirements, including the UEFA. And that would basically mean opening the door to rivals and preparing for more competition on the market. But sports federations might nevertheless keep the restrictive rules and not comply. And this is on the basis of what I have seen before. For instance, there is a notable example when a court judgment didn't even have an effect in a single sport. Bosman in 1995 said, the court said that discriminatory quotas in football, as we all know, were illegal, even though it had already established the same rule in regard to the same sport in 1976 Donna case. So the football did not even comply with a ruling that actually affected its sport, let alone other sports complying with that ruling. The second thing is that there is a politicization of enforcement, which has been an issue, and the Commission has been criticized for this quite a lot, because it's pursuing the negotiated solutions rather than opening formal investigations as a preferred approach. There are practically no ex officio investigations. It is almost non-existent. Most of the sports complaints are rejected, even those with profound union effect. And you've heard, Ben, and how much lobbying it took on political level to get Commission to open investigation at all. Now, private regulation, as Ben also said, is very much on the agenda of the European Commission, but this does not include the private regulation by the sporting regulators. The sports lobby is one of the most powerful in Brussels. So in terms of real effect in practice, as opposed to what it should be after the ISU judgment, it just basically remains to be seen. Thank you.
Thanks a lot, Katarina, for your analysis, which was certainly clearer and more exhaustive than the criteria of the sports rules you denounced. And then finally, I would like to give the mic to Antoine for an aspect that is maybe less well known of the award, but that touches upon well, one of Antoine's favorite topic, which is the clauses of arbitration in front of the Court of Arbitration for Sport. So Antoine, to you.
Thank you, Marjolaine. Yes, I abused my position as a co-conveyor of this Zoom meeting to allocate some time for my own reflections. So Ben, Steve, Katarina have already covered a lot of ground, and I'm not gonna repeat anything that they said. First, I would like to make a little disclaimer, but Ben already pointed at it. I mean, I was also part of this adventure in this case from the beginning and on the side of the skaters. It is, in fact, I think the only case I've been really part of in my life as a legal scholar. But you have to take my words with a grain of salt. There is a necessary bias when you're involved in the case, and I try to stay as academic, as detached as possible, but I cannot rewind my past involvement. So I wanted to focus really on the appeal arbitration rules of ISU and in favor of the CAS. And those of you who have followed, one second. Those of you who have followed the aftermath of the ruling on social media will know that this is probably the aspect of the judgment that has been most celebrated, especially by those who are supporters of the Court of Arbitration for Sports or of sports governing bodies in general. And in fact, I find it quite amusing that despite, the rather brutal critique of the General Court of ISU's regulations and the rationality of ISU's governance, it is also the reason why ISU welcomes the judgment in its press release and claimed and was really celebrating the fact that the General Court has confirmed that the CAS arbitration system is fully consistent with EU law. So yeah, you have to be a really good communicant, I think, to spin that judgment as a victory for ISU and its governance. It's a bit of an alternative reading of the judgment, I think. But I want to focus on that argument that the General Court confirmed that the CAS arbitration system is fully consistent with EU law. I think this is quite a stretch of the judgment, but I will explain why. So I want first to remind you what was in the decision about the ISU arbitration rules. And there you just have to go back to points 268 to 286. So that's section 8.7 of the decision. And the key claim of the Commission was that the appeal arbitration rules reinforce the restriction of competitions that are caused by the eligibility rules. Why do they do so? Because, and this is point 270, they make it difficult to obtain effective judicial protections against eligibility decisions of the ICUs that violate Article 101. And this is due to a number of difficulties that are linked to contesting awards. I will not go into details, but the Commission provide arguments related to the difficulty to challenge enforcement and at the enforcement and recognition stage an award in 284, the cost that is linked with the enforcement, with challenging an award, the time that is linked with that, and basically all this together makes it very difficult for athletes to, or any other party to challenge an award. And that's why the Commission considers that this creates an additional hurdle and for athletes to obtain effective judicial protections against potentially anti-competitive ineligibility decisions. And the consequence of that appears then in point 339 of the decision and the second article of the operative part of the decision, and it is important. It is mentioned that if the ICU were to choose to maintain a pre-authorization system, which it did, it would appear that the ICU can only effectively bring the infringement to an end by substantially changing its eligibility rules and the appeals arbitration rules. So the Commission was also demanding, there was no fine imposed as we heard, but it was demanding that ICU change its appeals arbitration rules. And this demand was challenged then under the sixth plea of ICU before the General Court and considered by the General Court. There are two aspects in the discussion of that plea. One is related to the effectiveness of the plea, whether you can plea that, because the Commission was arguing that this is not part of the infringement decision. This is not part of the finding that ICU contradicts EU competition rules. And the court basically says this does matter because you are requesting in Article 2 of the operative part that ICU change its arbitration rules. So it becomes relevant and it becomes something that you can appeal against, basically. But this is not really what I find interesting in the decision. What is more interesting is the question of the merits of the plea. And there, ICU, the Commission was arguing that the ICU arbitration rules would amount to an aggravating circumstances in the sense of its 2006 guidelines on the method of setting fines. And the key point, I think the key basis of the ruling is paragraph 153. Only unlawful conduct or circumstances which render the infringement more harmful can amount to such an aggravating circumstance. And that's the test that the court goes through. And that's where it will find that the arbitration rules do not amount to an aggravating circumstances. And it makes four arguments in this regard. The first one at paragraph 154, the European Commission recognized that recourse to arbitration is in general not a restriction of competition. So arbitration in general is not a problem for the European Commission. Second argument, paragraph 155, the European Commission did not consider that the applicant's arbitration rules infringe athletes' right to a fair hearing. This is an important point. The court did not consider whether the Court of Arbitration for Sport infringed or not the right to a fair hearing of the athletes, because the Commission never argued it. So some would say this might be a problem. I might be amongst those in general, but at least in the framework of the decision, the Commission never raised that as an issue, and therefore it is not a problem from the point of view of the General Court. The third point was linked to the bindingness or the forced arbitration nature. And there, I think it's a very interesting paragraph, paragraph 156 of the decision, where the court says that binding arbitration may be justified by legitimate interests linked to the specific nature of the sport, and it refers to Mutu and Pechstein, to the decision of the European Court of Human Rights, to hold that recourse to a single specialized international arbitral tribunal facilitates a certain procedural uniformity and strengthens legal certainty. So here you have basically the Mutu-Pechstein ruling of the ECTHR that is migrating into EU law. We are seeing it move into EU law to start to, as an argument to allow forced arbitration in the context of sport. And it's not that surprising to me. I mean, this is an argument I've been making in a way for a while, that we have forced arbitration and we can find justifications for it that are, I think, pretty convincing, and that convince as well the General Court. So, but this, I mean, this will cut both ways. You have to understand that this is a recognition of the validity of forced arbitration, but this implies that that forced arbitration needs to fully comply with due process rights as enshrined, in particular in Article 6.1, but also in the Charter of Fundamental Rights of the EU. And that might be the next test for the CAS. And finally, and I think this is even the more interesting point of the judgment regarding to arbitration, it is the one that is enshrined in paragraph 157 to 160. And in paragraph 157, the court basically said that any person is entitled to bring proceedings before a national court and claim compensation for the harm suffered, where there is a causal link between that harm and an agreement of practice prohibited under Article 101 TFEU. That's a standard principle. You can go to court and claim damages for a harm that you have incurred because of a competition law violation. But then paragraph 159, and that is where it becomes really interesting. The General Court is saying skaters may bring, if they so wish, in accordance with the case law cited in paragraph 157, an action for damages before a national court. In such cases, the national court is not bound by the CAS's assessment of the compatibility of the ineligibility decision or the refusal of authorization with EU competition law, and where appropriate may submit a request for a preliminary ruling. And this is interesting. Why? Because basically it denies any bindingness to the CAS award. The CAS award is deemed irrelevant before a national court or a national competition authority or the commission. And this is a bit of, I read it as a development on the classical jurisprudence of the Court of Justice relating to the recognition and enforcement of arbitral awards, starting with EcoSuisse. And in a way, as some of you may know, those that are specialized in arbitration, EcoSuisse has been read by, for example, French court in a very narrow way. So you could challenge the validity of an arbitral award that was dealing with competition law, or only if it was a violation of the EU competition law rules that is flagrant, effective, and concrete, or in good French, that crève les yeux. That was the appeal court of Paris. And here, basically, the way I read the decision of the General Court, it's definitely going against that interpretation of EcoSuisse to say that as soon as you have a competition law issue that is raised, even if it has been dealt with in the award, the court or the national competition authority or the commission must disregard whatever the arbitral body has said about that competition issue and investigate it again anew under its own procedures. So that opens the way for a lot of challenges, easy challenges, in terms of admissibility against decisions of sports governing bodies that have been confirmed by the CAS, on the basis of competition. And so actually, I think reading that judgment as an endorsement of the CAS is a bit misleading. It is an endorsement of the need of arbitration in sports, but it's also saying that CAS awards should not be trusted in competition matters and cannot hinder access to court or to competition authorities to raise issues of competition law compatibilities that have already been dealt with potentially in the award. So those are my main points regarding arbitration, and I think they nuance a lot that picture of a decision that would be extremely favorable to the Court of Arbitration for Sports. Thank you.
So thanks a lot, everyone. I think now the plan is that we first give our panelists the opportunity to react to each other's intervention. So I don't know, maybe Antoine, you have maybe some questions for other
I think
guests.
in light of the time, it's not a bad idea to turn to the question right away.
We also have a lot of questions coming in the chat. So there are various questions around the CAS, but maybe we will start with some more general questions, and I'd also try to take them in the order of appearance. So there is a first question with respect to the areas that could still be purely sporting. So don't you think that despite Mecca Medina, there are still areas which could be purely sporting? In Waldorf and Koch and Bosman, the European Court of Justice referred to selection for national teams. And so what about the size of soccer goals or rules on the equipment of the players? So it's a question about whether there could still be purely sporting areas. Who would like maybe to take that for first? Steven? Go ahead.
Yeah, of course, there must be rules that are purely sporting. If FIFA were to say that the goal should be 2 centimeters lower or 2 centimeters higher, then okay, it's a purely sporting rule. My argument is that there are very few rules that are purely sporting. If you take Waldorf and Koch as an example, the Court of Justice says that it's a matter of purely sporting interest as to how national teams shall be composed. Look, in Waldorf and Koch, the two cyclists had brought the litigation specifically because they were going to lose money as a result of the obligation to work with Dutch cyclists and only Dutch cyclists, whereas previously they had worked with Belgian and German cyclists. So the litigation in Waldorf and Koch existed only because it was not a purely sporting rule. It was a rule which had economic consequences for the athletes. And if you talk about rules on the equipment used in a sport, well, it has economic implications as well for manufacturers and sponsors. So I accept that there are some rules which are purely sporting and have no economic effects and are therefore not touched by EU law. But they're very specific, very narrow, and very rare and very unlikely to provoke anyone to want to litigate. So my argument is that it's much better to accept that almost all sporting practices also have economic implications, and therefore they fall within the scope of EU law. And then the really important questions are whether the sporting bodies can show that those rules are necessary for the organization of the sport and therefore permitted under European Union law, even though they might have economic effects. And allowing nationality discrimination in international sport is of exactly that type. Saying that the German national team is restricted to Germans has economic effects, because if you're not German, you can't play for it. You can't get your place in the sun, which sponsors would be very impressed by. But it's a rule, though not a purely sporting rule, that's necessary for the organization of international football.
Ben, you want to add something?
Yeah, if I may add to that, I fully agree. I mean, the choice of equipment is perhaps an unlucky example, because there have been quite a lot of competition cases on the type of tires that Formula One needs to have, or the equipment of the players. But I wanted to add that in Mecca Medina, also the court did something strange by emphasizing that even if a rule does not have economic implications and therefore falls outside of the scope of free movement law, that would still not necessarily mean that it is outside the scope of Article 101. So it seems to have a different standard for the competition rules than for the free movement rules. So that might even further narrow the scope for still a purely sporting exception, at least for competition law.
So we have lots of questions coming in. It's difficult to follow. I think Kevin had an interesting question, and I don't know. I think Ben, you might want to weigh on that question. He was linking, making a parallel between social media monopolies and that in the US hide behind immunity of Section 230 and sports governing bodies. Do you have anything to say about that?
Sure. I think I made the parallel myself. I think you can certainly make the parallel, and you could to some extent see the big tech companies as a sort of private regulator, but then I guess of internet or of certain services. I do think I mean there's still an important difference. With sports, in my competition law courses, I always give the example. I ask students, give me an industry where you have a 100% monopoly. Those are quite rare, unless they're regulated by public regulation. So surely in sport, you have quite a powerful gatekeeper, even more powerful than Google. Plus, the problem with the big tech companies is, of course, leveraging. They leverage their power to nascent markets, etc. I guess with sports, the issues right here is really access to the market. If you cannot have any athletes in your event, then you cannot have an event. Simple as that. So this is more about exclusivity, actually tying exclusively the athletes to yourself and saying it's like a non-compete, right? You cannot go work for the competition. So in that sense, I mean the issues are different, but I do see a parallel. They're both gatekeepers and both powerful gatekeepers. Yes.
And maybe picking up on that, I think there is a question for all three of you that will be relevant. That is linked to the FIBA EuroLeague dispute by Hubert. Hubert is someone that follows our work quite closely, and a great basketball player. But he's really asking about the implications of the ISU ruling on the ongoing FIBA EuroLeague dispute, and if you have something to say about that. What do you think? Maybe Katarina first, because I know that you've been looking at that case quite closely.
Yeah, I haven't been looking at it quite closely for quite some time, and there's a reason for it. It's because it's pending before European Commission for 5-6 years already. And we know that even European Parliament has urged the Commission to do something about this case, to open up the investigation. So there's that point that I made about the lethargic enforcement and the way that it's happening. So the question by Hubert was, what do you think would be the implications of ISU for this particular dispute? Well, first of all, there are counterclaims here. So it's not only that an alternative organizer which exists on the market and functions on the market is launching against the governing body, but there's also a counterclaim against the governing body against the alternative organizer. And I've looked into it. I think that both of the claims there is merit to their claims in both cases. So in terms of how can this affect the judgment or the decision of the Commission if they open up investigation at some point. Obviously, everything that has been said in ISU is going to affect the decision. I have prepared a kind of a slide with a type of or the way that the thinking should be around these things. I do remember that the FIBA was accused of putting pressure on national associations, and there is a lot of things that actually are not directly addressed by the ISU, but have implications for it. And I do think that FIBA can win its case against the alternative organizers, but I also think that the alternative organizer can win the case against FIBA. And the best thing for the both parties would be perhaps to sit down and negotiate at this point. Because the alternative organizer, Hubert, in a particular case that you're citing, are quite powerful clubs that also are competing with the governing bodies for the services of the elite clubs, and they themselves have been accused of tying, for instance, of certain governance issues, such as that only 6 clubs are making really decisions, and to the exclusion of all others. So there is a governance problem, and in competition law, even though it is normally taken to address the external dimensions of undertakings, such as their relationship with consumers and markets, rather than that internal dimension of governance, competition law, in fact, now has enough cases and enough precedents that we can say that it can address the governance issues as well, such as compositions of the boards, which was not in sporting case, but there is a case called Anonima Italiana, something like that. Apologies to Italians for the pronunciations. Basically, the composition of the board that was making decision was held as a part of the reasoning as to why there was a restriction. So the governing issues can be also addressed. Again, the issues are a bit different in FIBA case, but there's a lot of implications.
Maybe Steve, or would you have something to add on the FIBA case, Ben?
No, I think the factual matrix is quite different. I think what Steve already said, the decision is a blueprint in the sense that it is the second generation, it sets out the framework, how to make the analysis. But then, of course, it all depends on the facts of the case. I just wanted to say the FIBA case is, well, it's not a case per se, but it's a good example of the fact that filing complaints to a competition authority doesn't necessarily mean that you will have an effective application of the competition rules, which the court seems to assume in theory you can always file complaints with competition authorities. Well, this is a good example that it doesn't always work. And I think in the beginning I emphasized we got lucky, but it's certainly not a guarantee that you will have access to antitrust scrutiny.
Okay, then I have a number of questions that relate to arbitration that I will take in a group. One by Santiago, whether it would have been different if the cast would not be seated in Switzerland. It doesn't, this is not really referenced in the decision. So it seems to be, the way it is written, it seems to be very broad. And I'm not sure it's restricted to CAS. And that would be a big question in terms of the implication of that paragraph 159, whether it means that in case of any award, a national court or a national competition authority or the European Commission are entitled to simply disregard the assessment of that award of competition law. That's the way I read it. If it's like that, it is basically throwing out of the window a lot of the French restrictive interpretation of EcoSuisse. So that might be a big thing that is hidden in a very specific ruling that very few people, I think, that are specialized in arbitration have noticed. And that connects, I think, to Saverio's question, indeed, CAS panel has started to address issues of compatibility with EU law. You have it in Galatasaray, you have it in the TPO decisions, you have it in a number of decisions. And the question is, well, is it worth it? And it's a good question, Saverio. And but I do think that while, let's say, national courts are not bound by the reasoning, they will be necessarily influenced by it. And this is a bit the type of annex situation that we had in 20 years back, where basically the Commission was strongly influenced by the CAS award in its dealing of a complaint that involved a similar factual constellations. So if CAS awards are doing good EU competitional reasoning, they have, I think, they will still have more chances to stand in front of national courts or in front of competition authorities. And there should still be a strong interest from the side of CAS, but also from the side of the parties involved to make sure that their words are solid on competitional grounds. But they will not, there will not be a guarantee.
Yes, Antoine Despina was asking about the res judicata effect. How do we reconcile the ISU judgment finding that parties bound by a CAS award can still bring a claim for damages, which would unavoidably touch upon the issues that have been decided in the CAS award? So are you saying that actually there wouldn't be any such res judicata if you read the ruling?
It's done. The national court is not bound by the CAS assessment. That's a wording of the. I think there's no. Steve, you have a different reading?
No, I have the same reading. I think that the point is that these are two completely separate legal systems, which nevertheless come into contact with each other on occasion. The two different legal systems here are what I call, on the one hand, internal sports law, and on the other hand, external sports law. By internal sports law, I mean the rules and the practices of sports governing bodies, the dispute resolution procedures which are foreseen by the constitutions of sports governing bodies, and ultimately the decisions of the CAS, the apex of what I call internal sports law. Then external sports law is the application of the law of states and of international organizations to sport from the outside. External sports law and EU law is the form of external sports law that we're concerned with today. It's the application of EU law to sporting practices. Now, a lot of the time, internal sports law and external sports law don't touch each other. The CAS is very well developed. Internal dispute resolution in sport is very well developed. Most disputes are handled through internal sports law. They may go through the dispute resolution procedures, they may go to the CAS, but they stop there. But just occasionally the issues spill over beyond internal sports law and they come into contact with external sports law, with EU law, and EU law will claim a jurisdiction. And the two powerful examples, which we've already heard about, first of all, are Mecca Medina. Now, in Mecca Medina, the swimmers had been the subject of a decision by the CAS. The Commission and the court nevertheless took the view that the matter was subject to review under EU competition law, quite independently of what had occurred through the CAS. So in Mecca Medina, the Court of Justice was saying there is EU law and we will apply EU law, even though the same set of facts might have generated a resolution of the matter within the sports system, within internal sports law through the CAS. And then there's EcoSwiss. EcoSwiss is the Court of Justice saying that even if there is a decision taken which is final for the purposes of arbitral law, if that decision is in conflict with EU competition law, then it violates public policy under EU law, and therefore EU law will not regard internal sports law as having the last word. Instead, EU law will insist that a national court reopen the arbitral award and ensure that the violation of competition law is corrected. And the Court of Justice has never said that about free movement law, but exactly the same logic must run, that EU law insists on the opening of arbitral awards if they are contaminated by the violation of EU public policy rules for competition law and free movement law. Now, that means several different things. It means that EU law is relatively intolerant of arbitral finality. EU law places public policy, competition law, above arbitral finality. Some arbitration lawyers are horrified by that. Some national courts simply don't accept that and interpret Eco Suisse in a very narrow way. But that is the claim that EU law is making. And from the EU law perspective, the best thing to happen here would be for the CAS and arbitral proceedings in general to absorb and apply EU law accurately and fully, so that there's no need for national courts to reopen arbitral awards for violation of EU competition law. So that, I think, would be the ideal solution. But pending that, EU law is attentive to the importance of competition law, and because of that attentiveness, it will not accept arbitral finality if competition law is being compromised.
Yes. And I think the striking thing with the judgment is that it is really extremely assertive about that refusal to accept. And in that regard goes, I think, beyond Eco Suisse, and it does not enable the type of interpretation of Eco Suisse that were promoted in particular by the French court, which were basically narrowing it down to the most egregious, evident cases of competition law violation. It's actually calling for reopening that assessment each time. So this is a considerable statement, I think, in terms of distrust to some extent of CAS in particular in that case, but also of arbitral mechanism in general to deal with competition law issues. So it's quite an important move by the court.
We are quite flooded in questions, so I'm quite sure we won't be able to take on everyone, unfortunately. There was a different question, which I think refers to what Ben said in his presentation about further steps. A question from Mark Orth that you mentioned further step, would be interested what these further steps are about. So I think he refers to the fact that you said that you believe the ruling went actually further than in some respects than the European Commission decision. So maybe you'd like to comment on that.
Sure. I think I first interpreted further steps in the sense what's going to happen now. I don't have any
so
information.
Maybe it was that. No, you can answer both.
It might be, but I have no scoop, no information whether that's going to be appeal. I think the deadline is still a few weeks away. Whether the Commission will appeal or the ISU would appeal, we'll have to wait. We have to wait and see. So if that would be the further steps, then I don't know.
And with respect to what you said, that the ruling may have gone further than the European Commission or the general, yeah.
Sure. That point, I think. What the General Court does, it really embraces the motu logic, which was, of course, a case involving Article 106 and 102. And the Court of Justice has applied that logic in the OTOC case, the Order of Accountants, or I think that case was, and brought it also in the sphere of Article 101. But I think the General Court is quite strict in saying, you are a gatekeeper. So you need to have these objective, transparent, non-discriminatory criteria, and any scope for discretion will inherently invite abuse. I mean, this is not an abuse case, but it's kind of the motu logic. And that the General Court says that as soon as you have any type of discretion, so as a result of your distorting competition, you end up with a restriction by object, is quite a far-reaching conclusion, I think. So yeah, in that logic, one has to be, I think the Commission was a bit more careful in phrasing it. You have to be very, very careful because as soon as you distort competition by not sticking to these friend terms and objective criteria, etc., in this instance, you end up with a restriction by object. So this is almost imposing a special responsibility on an actor in a 101 case. It's not a 102 case. So in that sense, it uses element of 102 and MOTU and applies this in this case. I think in a more far-reaching way than the Commission perhaps did in the decision. So that's what I meant.
I think there is a question that I find quite interesting was from Blash on the proportionality of sanctions in cases of breaches of eligibility. And he wonders whether ineligibility should not be an ultima ratio sanction reserved for really severe breaches. So how do you, maybe, I don't know the three of you, but how do you read the impact of the judgment regarding to the type of sanctions that sports governing bodies can impose in eligibility cases, and in which context can they impose different types of sanctions, fines or ineligibility?
Well, I can try to answer that one. The question regarding the proportionality, shouldn't the imposition of ineligibility be the ultima ratio sanction reserved for really severe breaches? First of all, what is a real severe breach is a question. If an athlete participates knowingly in a competition that he knows would not be authorized, would that be sufficient to characterize it as a severe breach? And I've shown on one of the slides the current amended ISU rules from the Constitution and general regulations from 2018. And there you could see something that I think could pass a proportionality test. Considering also, and this is a bit of a controversial statement perhaps, but do tell me what you think. Considering that the prior authorization system in itself is now in line with law, and considering that it is applied proportionately and applied properly, and it exists as it should, as per those legal parameters, does that mean that anybody who is actually unauthorized is breaching one of those sacred things in sports, such as, again, safety of events, integrity, and stuff like that? So if that is the case, obviously athletes should be discouraged in some way and deterred from participation, and warning will not do it. So some kind of ban would be necessary to prevent third-party organizers popping up and organizing competition without license and not complying with things like uniform standards, safety of events, integrity of competitions, and not getting anything, very limited methods to pursue these organizers. But that is why sanctions on athletes are one of the ways that governing bodies can prevent such, let's say, wild organizations from happening. So I think that it is not really the last option for the organizers, but it is something that they should, if they have, and of course, always assessment will depend on what is happening with prior authorization system, how proportionate, how well administered it is. And if it is properly administered, and then yes, athletes should get some sort of deterrent sanction, something, and that is not warning. So we do know now from ISU, the commission decision, and we do know from the court's case now that 5 to 10 years would be too disproportionate in the sport like speed skating, where the careers are 8 years long. We do know that lifetime bans are disproportionate. We do not know what is proportionate. That is the question that is left open. But looking at the current ISU Constitution, General Regulation, rules on eligibility, I would argue that they are proportionate, with one notable exception, and that is that they should define clearly whether the athlete will get a warning, a 6 months or a 1 year ban in case of the first offense, and in case of any repeated offenses up to 2 years. So it is quite a big difference between getting a warning and 2 years ban if your career is 8 years. So that is one thing they should probably change, so that there is no scope for any arbitrary decisions. Otherwise, I think that would be a good example of perhaps proportionate sanctions on athletes currently.
Oh, I think Steve wanted to say something.
Just briefly, I mean, I agree with all that. I think it's really hard to talk about this in the abstract. It depends on the particular circumstances. I could imagine a situation where a non-authorized event is put on because the organizer thinks it's so low level that there's no need to apply for authorization. An athlete takes part in that event and is the subject of sanction. That would have to be a very mild sanction. On the other hand, if you had a situation where a third party had applied to host an event and the federation had said, no, your safety standards are not good enough, you must not put on this event, and they nevertheless put on the event, and an athlete took part knowing that the safety standards were not complied with and that authorization had been refused, then that would be a much more severe sanction. But it really depends on the circumstances.
Yes, Stephen. There is in ISU Constitution, it is kind of now like almost like a model, because this is the only sport that I am aware has this detailed and clear rules that comply mostly with law, apart from that minor thing I mentioned. But what they say is that there is a no fault finding for a first-time breach where the skater participated in an event that would clearly have been sanctioned by the ISU, but for the administrative error of the organizer of the unsanctioned event. So if there was something minor and they otherwise comply, that is a no-fault finding. Or there is a warning for the first-time breach where the skater was reasonably aware that the event was not sanctioned, but has demonstrated that the event otherwise adhered to objectives of the ISU protected by the eligibility rules. So there is absolutely nothing if an organizer throws an event that perfectly complies with sanctions, and they can do this every single time in ISU. And athletes will not get anything but warning, and that is a certainty. And organizers can just skip the licensing in ISU altogether. Because if they comply with everything that normally would be required by the license, and they can get skaters to participate. The only problem with this, as I said, is that I see that skaters have to assess by themselves whether or not that event complies with all the standards required. And that's where the unions would come in handy. To actually provide some legal advice, perhaps, and perhaps then in practice there would have to be some trust established between such organizers that are complying with everything but are not really bothering with licenses, between them and athletes, so that athletes can know that this is the trustworthy organizer and we are not going to be sanctioned because they are complying with everything. That is ISU specific now.
If I may add to that with an ISU specific example, I think I fully agree. Yeah? It all depends, as Steve said, it all depends. If it's an unsafe or corrupt event, then obviously we don't want athletes to go there and we should protect them against themselves. But for example, in the code of ethics still of the ISU is that there can be no link with betting, no link with sports betting whatsoever. So that means that a third-party event cannot have a betting sponsor, for example. Well, Katarina seems confident that, you know, you'll have warnings. Well, actually, an athlete should know that an event that has a betting sponsor would never be accepted by the ISU. So then you come into the sphere of these harsher sanctions. And there I clearly think a 1-year sanction or a 2-year sanction, simply because that event has perhaps a betting sponsor, that doesn't make it a corrupt event at all. If so, then every sports event in the world is corrupt. Then this is clearly still disproportional. But of course it depends, and
yes, and
you
that
can only
is
assess it on a case-by-case basis.
That has been taken into account by the rules. What I was referring to is those that are perfectly compliant with all the rules and all the standards, and then athlete participating in those unsanctioned events. And there is a rule that is different, where the warning or 1-year ban is imposed on for the first time participation in a non-sanctioned event that did not comply with those rules. And then up to 2 years, a warning or 2-year ban or anything in between if there is any repeated offense. And now this should be clarified. This is the part of the rules that I think might not really comply with the transparency criteria, because it leaves a scope for the for the sports federations to simply apply arbitrary decisions here.
Yeah, we have to wrap up, but I think this discussion is definitely where, let's say, the debate will be moving in the years to come about what is a proportionate sanction. When is a sanction proportionate, in which circumstances? So we are not at the end of it. The ISU is not the end. It's really the beginning of a wider debate on, as well, the sanctioning policies of sports governing bodies in general. We're talking about the ISU, but I think every sports governing body should be aware of this case and reviewing its disciplinary rules and very carefully assessing the sanctions that are connected to a particular behavior, because this case opens up a way for athletes in particular to challenge those sanctions that will be imposed in eligibility cases. So I want to thank our 3 speakers for joining us. Thank the audience for also joining us in this second Zoom in. There are so many questions that we couldn't address, and it's frustrating, but it's also satisfying to see that there is so much interest and also really an interesting and engaged audience that puts tough questions and takes the time to write them down, which is not always as well as easy as asking them orally. So I want to thank both our speakers and the audience. And I think Marjolaine wanted to say a few words about the next Zoom in.
Yes, thanks, Antoine. Well, first, I just want also from my side to really give warm thanks to our guests. I think I learned a lot myself, and I could see that there was almost a parallel expert debate going on in the chat. So the audience was equally very participated, and I think we hardly lost anyone over these 1.5 hours. So either they fell asleep on their screen, or they were really fascinated by the discussion. Yes, we will try to keep up that monthly rhythm of Zoom ins. We have a few candidates for the next session, but we would probably anticipate that the CAS award and the WADA versus RUSADA matter would probably be a likely candidate for the next Zoom in session. So we look forward to seeing you again, and thanks to the guests, thanks to everyone, and have a good evening, everyone.
Bye.